organization. And it is my great honor to welcome you to all to today's webinar, where I'll be the moderator. So, on behalf of the organizers, the Center for Legal Aid and Clinical Legal Education and the East Africa Child Rights Network, I first want to thank the audience who have spared the time to join us and participate in this great discussion. Your presence here reflects the importance of today's discussion and one that sits at the intersection of children's rights. So this webinar, it is the second webinar organized by CLACLE, and it is a webinar series from judgment to justice. It will seek to move the conversation from judgment to justice by reflecting on the landmark decision of the African Committee of Experts on the Rights and Welfare of the Child in the Nubian Children's case, and what it continues to mean for Kenya and the continent. So, among the objectives of today's discussion, there will be to examine the African Committee of Experts on the Rights and Welfare of the Child's finding and their contribution to children's rights jurisprudence in Africa, assess Kenya's compliance with the committee's recommendations since 2017. Noteworthy to note is that the decision was made in 2011. After the decision, there was the compliance report in 2014 and the committee's recommendations in 2017. So we'll seek to highlight the trajectory that the state, Kenya, has made since then, and if there are any present challenges. Then another objective it will be to highlight the ongoing challenges Nubian children face in accessing nationality, education, and healthcare. To create a platform for dialogue among academics, policymakers, and community actors on compliance and accountability. So to facilitate this, we have a very rich panel. The panel is composed of Mr. Shafi Ali Hussein, who is the Executive Director of the Nubian Rights Forum. We also have Mr. Benedict Omilo, who is the Secretary General of the Eastern Africa Child Rights Network of Civil Society Organizations. We are also privileged to have Professor Robert Nanima, who is a member of the African Committee of Experts on the Rights and Welfare of the Child, and Mr. Edmund Foley, the Executive Director of the Legal Aid Commission of Ghana, and the former Deputy Executive Director of the Institute for Human Rights and Development in Africa. We also have, among the panelists, we'll also have a student clinician who will provide insights of the facts in the legal issues of the case, named Young Peter, who is one of our clinicians. So with that, I wish to welcome our first panelist, who is Mr. Peter Youngren, a student clinician at Kabarak Law School, who will provide an overview of the Nubian children's case, including key facts, legal issues, findings of the committee, remedies ordered, and the decision's broader legal significance. Over to you.
Good afternoon to you all. As introduced, my name is Youngren Peter Modei, a fourth-year law student at Kabarak University and a clinician in CLACLE. So before I dive into the case, I just took time to do a brief research and see the history of Nubians in Kenya. So just a brief highlight of the history of Nubians in Kenya. They are descendants of Sudanese soldiers who were largely brought in Kenya during by the British over almost a century ago. Then they've lived in Kenya for generations, because you label 1 century. Then most of them settled in Kibra in Nairobi. Then if we speak about Kibra, we all understand of the harsh life that is there in Kibra. So most of them were viewed historically by the government of Kenya as squatters who did not have any land rights. Then the effect of this is the same transition to their children, who remained stateless even at the time of their birth. So unlike many Kenyans who were able to get citizenship at birth, for them, citizenship and nationality was not a guarantee. Even at the time that they attained the age of 18 years, many of them faced a lot of problems when they tried to even apply for identity cards, because we all know the process that is involved and the requirements that are needed when you're applying for an ID. You're asked for the identity card of either your parents, your mother, or your father. And from that instance, both their parents did not have the identity cards. Another problem that they faced before this case was filed was that there's a time in Kenya in 2013 where a requirement was brought that for you to enroll for exams, and this is now after the termination of the case, for you to enroll for exams, the national examinations and all that, you had to have a birth certificate. So the impact of that is even the Nubian children could not be able to sit exams, and their right to access education was limited. So in the late 2000s, from the research that I did, the three main problems that the Nubians were facing in Kenya, and specifically the children, is there was no automatic citizenship that was given to them at birth. Then the second one, I summarize it as they faced a burdensome vetting requirement when they were applying for identity cards when they attained the age of 18 years. Then most of them, because of the failure to have an identity card, they did not have access to essential services and essential human rights, like the right to education, the right to healthcare. So in 2009, two organizations, that is the HRDA and another organization, they filed a complaint before the African Committee of Experts on the Right and Welfare of a Child on behalf of the Nubian children. And they were complaining that they were alleging that there were violations of some provisions of the African Charter on the Rights and Welfare of the Child. The first provision that was the main provision in that case was Article 6 of the African Charter on the Rights and Welfare of a Child. And we know very well that Article 6 of the Charter makes a provision for the right for a child to naming and nationality. Then the second right that they were alleging infringement was Article 3 of the African Charter on the Rights and Welfare of a Child, which provides that no child is supposed to be treated differently based on either their ethnicity, their religion, or their origin, or even the status of their parents. Then the other provision, now that they were claiming was infringed, based on the infringement of Section 6, was Article 11 of the same charter, which makes a provision on the right to education. So they stated that the infringement of Article 6 hindered their access to education because they could not have birth certificates to register for examinations. At the age of 18, they could not easily get IDs. So they were barred from accessing a lot of these. Then also there was a claim for infringement of Article 14 on the right to healthcare. So when the complaint was filed before the commission on two instances wrote to Kenya, who were the respondents in that matter, for Kenya to respond. But Kenya did not respond in those two instances. And the committee proceeded to issue a decision even without a response from Kenya. And when the committee was writing the decisions, they acknowledged the fact that one of the defenses that could have been raised by the Republic of Kenya was that local remedies had not been exhausted. Then they went back to the rule on exhaustion of local remedies and the exceptions to the rule. So in instances where local remedies are ineffective, that is even if they are available. So on that argument, the two human rights organizations clearly stated that they had filed matters before the High Court way back in the early 2000s. Then when the matter was before the High Court, the file was transferred to about 5 judges. Then between 5 judges, then as the matter was being transferred, there's a time that a letter was written to the Chief Justice for the Chief Justice to be able to address the matter, but no reply was found by the Chief Justice. So for that, the committee concluded that the doctrine of exhaustion of local remedy was inapplicable in this instance because they had tried, but the local remedies had proved to be ineffective because it was almost 5 years and no decision had been taken, no action had been taken on the files that had been effected on the same. So on the 22nd of March 2011, the committee now gave the decision, the final decision, and they found that there was violation of the various articles as was alleged by the two human rights organizations that brought the complaint on behalf of the Nubian children. So they highlighted that Article 6 of the African Charter on the Rights and Welfare of a Child demands that every child should have a nationality at birth. Then they stated that registration at birth has a very great link to the right to nationality, and that is why both of them are contained under Article 6. So they stated that from the moment that a child is born, the child should get registered, then have a nationality, because the effect of that was to render a child stateless. Then they even went further and explained what statelessness means. Then they stated that statelessness is antithetical to the basic principle that we all understand on the best interest of a child, which they stated it's a key principle and a guiding principle in every single instrument that speaks about the rights and welfare of a child. And they highlighted the provisions that were there in the previous constitution of Kenya, and even stated how the same was elevated in the Constitution of Kenya 2010 by the enactment of Article 14, which we all know requires that a child who's under the 8 years, then they are found in Kenya, and they do not have a parent, then they are presumed to be citizens of Kenya. But they proceeded and stated that that alone is not concrete enough to be able to grant Nubian citizens the protections that they require, and especially in this instance, children. Then on Article 3, they stated that the vetting process that was accorded to children who attained the age of 18, Nubian children who attained the age of 18, was discriminatory, simply because the vetting process was not the same vetting process that was given to Kenyans, other Kenyans who applied for IDs at the age of 18. So they labeled that provision to be specifically discriminatory, and by that it infringed Article 3 of the African Charter on the Rights and Welfare of a Child. Then on Article 11 and Article 14 on education and health, their analysis was it's very hard in Kenya for you to have access to healthcare and for you to have access to education if you do not have the registration and you do not have a birth certificate. So that was one of the angles that they took to find that that has been violated. Then the second angle that they took was to look at the situation and the place that Nubians were living in, that is in Kibra, and just compare the healthcare facilities and education facilities that were available in Kibra vis-a-vis the facilities that were available in other places in Kenya. And by that, they found that these people had been discriminated. They had been secluded from access to rights that were granted to other children. So by that, they found that, because of the doctrine of the interdependentness of rights, then Article 11 and Article 14 had been violated. And from that, they gave some remedies and recommendations on what Kenya ought to do. And one of them was they told Kenya that they need to ensure that children of Nubian descent who will be otherwise stateless can acquire citizenship, or they can acquire nationality at birth and with immediate proof of citizenship, and they directed Kenya to legislate on the same. Then the second one was they directed Kenya to swiftly issue nationality documents, that is birth certificate and ID cards, to Nubian children or youths who are currently lacking the same recognition. And they also advised them to be able to legislate on the same. Then they also directed them that they are supposed to make registration at birth non-discriminatory. So the standard that applies to other children who are not Nubians should be the standard that applies to Nubian children. And now just to the last part, post the case, because I was reading and conducting research to see how far has Kenya gone with the implementation of the decision. So in the first years, that is around 2011 to 2013, after the decision was rendered, there was slow progress, and there's no step that Kenya took to be able to implement the decision. No reforms were enacted, and the discrimination still persisted. Then in 2013 to 2014, there's a report that was prepared by different NGOs, including Namati and one of the NGOs that instituted the matter before the committee. And they were collecting evidence from people who lived in Kibra, the Nubians. And they recorded that even after 1 year, from the data that was collected, 900 plus Nubian cases still showed that there were barriers that applied. Most Nubians were not given registration at birth. Then parents who would apply for birth certificate could face hurdles, and some of the parents were even turned away, and for some of them, they were told to produce extra documents for Nubian applicants, documents that were not required for other Kenyan citizens who are applying for birth certificates, parents who are applying for birth certificates on behalf of their children. Then in 2017, the committee reviewed Kenyan progress, and they still urged for faster action to be taken. Then in 2019, Kenya, via the Gazette notice, they were able to establish a national task force on stateless persons for the task force to be able to aid in getting solutions. So the function that was to be performed by that task force is that they were to identify stateless groups, then in the country like Nubians, then they were supposed to diversify the criteria for vetting or registration. Then they were also to give recommendations on what should be done for these people, stateless people, to be granted citizenship. So this move was applauded because it was a clear show that Kenya was willing to acknowledge that there is a problem, and they were willing to try and find a solution to this problem. In 2019, before 2019, there were some stateless people who were integrated. For example, the Shona, then just other communities. But up to date, from the research that I've conducted, Nubians are still facing the same problems that they were facing, though some steps have been taken. But Kenya has not yet fully implemented the decision that was given to them and the recommendations that were given to them by the committee. So for me, this decision stands out for various reasons, because one, it was amongst the first decisions in Africa that set precedents and affirmed the importance of children having the right to nationality. Then secondly, what I loved from the decision is the fact that they were able to also reference other
Thank you very much, Mr. Youngrin, for that detailed and groundbreaking analysis of the case. You've taken us to both a history class and a law class. Thank you for that. So Youngrin also went ahead to provide what Kenya has done to implement the decision, and with that, we say thank you. So one of the things that Youngrin mentioned is that among the parties which instituted the case was the Institute for Human Rights and Development in Africa. So with that, I will welcome our second panelist, Mr. Edmund Foley, who during the institution of this case, he was working with the Institute for Human Rights and Development in Africa, and he was a key member in prosecuting this case before the committee. So Mr. Edmund Foley will reflect on the role of strategic litigation in advancing children's rights in Africa, drawing from the Institute for Human Rights and Development in Africa, Africa's involvement in the Nubian children's case. As I mentioned, they participated in the case. And the presentation will also examine the litigation strategy adopted. He will also tell us, since I know among the audiences we have law students, we also have people from the civil society organizations who are also interested in instituting such matters before such committees. So with that, he will tell us the challenges they faced in prosecuting such cases. And noteworthy to mention is that, as Yangrin said, Kenya did not participate in the proceedings. So Mr. Edmund Foley will tell us what was the feeling of instituting a very pivotal case, and then Kenya not participating, because ideally Kenya was the respondent, but they were served and everything and they did not participate. He will also highlight the broader implications of the decision for access to justice, statelessness, and accountability of state parties under the African Charter on the Rights and Welfare of the Child. Mr. Edmund Foley, welcome. You have 15 minutes for your presentation. Thank you.
Thank you very much. Thank you, Joshua. And warm greetings to all my comrades in Africa. It's interesting, you've pulled me back to my civil society days. Now that I say I'm a government person, yes, working for the Legal Aid Commission of Ghana. But permit me to just pay tribute to a very dear brother who shared an office with me during the days of the Nubian Children's case, Mr. Humphrey Sipala, who is also on this call, and who, to all intents and purposes, was very much a key part of putting this case together, this brief together, and to all colleagues in IHRDA who made this happen. But also to mention colleagues from the Open Society Justice Initiative, colleagues from Semiride in Kenya, Korir, Singwe, and co, and perhaps another group of unsung heroes in all of this. When we were collecting the evidence, the bulk of the evidence was collected by a team of students from the Allard Lowenstein Law Clinic of Yale University. One of those students today is a professor, Matiangi Sirleaf. I've followed her progress. She's done a lot of work on transitional justice in recent years. So I think there's so many people behind this, but I guess the greatest heroes would be the Nubian children themselves and the Nubian adults. So you asked about sort of the strategic entrance of this case. It actually began with what I would call the Nubian adult case. There was a communication that the Institute for Human Rights and Development in Africa was working on behalf of, let's call them the Nubian adults, on the question of their nationality as Kenyan citizens. But the African Charter on Human and People's Rights did not have a provision on the right to nationality. So that case was being brought on the basis of the right, violations of the right to discrimination, basically, the freedom of against discrimination. And along the line, while we were looking at that case, we also saw the opportunities to actually break jurisprudential ground. And this is where, of course, the law students and other lawyers who want to look into this area of strategic litigation might borrow a leaf or two. We saw that Article 6, as had been mentioned in the summary of the case, was a clear provision on the right to nationality for children in the African Children's Charter. But we sought not only to bring that up as a strong ground to argue the children's case, but to also insist that this article be interpreted through this case as providing a right to nationality at birth. Because when we came into Kibra and to collect the evidence, it was obvious that the birth certificates that were being issued by the government clearly stated it was not a guarantee of nationality. But given that these children and their parents had no clear prospect of getting Kenyan nationality, then they were, of course, going to remain stateless ad infinitum, forever. And so that was one of the main entry points for us in putting together this case and arguing it. With the kind support of the Open Society Justice Initiative, we were able to get on the ground in Kenya. I had the privilege of coming down to Kibra, staying with the community, documenting, and also we took some affidavits from Eldama Ravine, I believe. Yes, it's been quite a while. You jogged my memory very well today. But it was good. We got some very good affidavits to support the legal arguments we were making. And I think I will not belabor the point. I think our brother Young Green has laid them out very clearly. But just to highlight some of the things that stood out in the evidence when we were collecting it. For example, we, and I know this might be a touchy subject for a Kenyan audience, but we need to still say it. But one of the children, for instance, in demonstrating the impact of not having his nationality determined on his socioeconomic rights, said that he was living with his grandmother. He had lost both parents, but was living with his grandmother, and they depended on the rent they were collecting from other inhabitants. And he mentioned, of course, a particular tribe. I think I would keep that for the moment, but a noted Kenyan tribe, and said, my grandmother does not get the rent to be able to take care of me because this tenant is able to look her in the face and say that you are not a Kenyan, and would proudly mention his tribe. And for this child, the way he even presented that matter spoke volumes. So we were beginning to see how we are able to draw parallels with this and the impact of not having your citizenship determined and how it cascades onto other rights that you enjoy. So it was affecting how much money his grandmother was making to be able to take care of him. And this was an 11-year-old boy. It was quite striking. He was able to really make the connection. This was not from us. Apart from the MSF clinic then in Kibra, they could not access any other clinic out of the community. Another bit of evidence that stood out for us was when another young boy would say that when he goes to school, they call him dirty. That's what other children call him. And they call him that because of his skin. But not only that, because the community, the people around who were not Nubian would say, excuse me to say that Nubians were dirty people. And this impacted on his dignity. I still recall that child's face with tears streaming down his eyes, saying that they call me dirty. And this for us spoke volumes about discrimination. And I mean, permit me to say humbly that I argued the case that day at the committee. And when the decision was handed down in 2009, I recall 2011, yeah, I think 2011, I stand to be corrected. When I thanked the committee members, one of them said, well, we didn't do this for you, we did it for the Nubian children. Then another committee member interjected and said, but didn't you see the way the man argued with his life? And I do recall, yes, I think I argued with my life because of some of these experiences I'm sharing with you. So again, to colleague lawyers and the law students, I would say in terms of strategy and your approach, put yourself in it. I think it was revealing for me. And I was very happy I had the opportunity to walk at least in the shoes of those children and the Nubian elders when I came down to the community as head of legal aid now. It's really been an eye-opener when I've gone down to some of the communities in Ghana where people have no prospect of getting justice, and it's influenced the way I do my work. Now, in terms of the actual engagement with the government, you asked, Joshua, yes, the government did not come that day to argue. But interestingly, we had a sort of amicus brief from the UNHCR. They had sought audience to come and make a statement or make arguments to support, the committee, essentially enlighten them on the Nubian situation and the growing potential for statelessness in a debilitating manner. But ironically, the representative of UNHCR who came in was a Kenyan. So at least you had somebody who was also familiar with the situation on the ground. And so that amicus came in. But I must say that the committee, in the absence of the Kenyan government, did a very good job at playing devil's advocate and ensuring that it was not a one-way street, for the applicants. Let me also pay glowing tribute to one of the people who argued with us, in fact, a champion for human rights in Kenya, the late Adam Hussein Adam. May God rest his beautiful soul. Adam was with us in that room that day. And an epochal moment in arguing this with Adam's presence was a question that was posed to us by one of the panel members that Kenya is noted for being an athletic country and winning many laurels in athletics. Has there ever been a Nubian athlete? Because, of course, if you're not giving them what do you call citizenship, then you were benefiting from, if ever there was a Nubian athlete benefiting from, their success, whether there was such a thing. And I must say, I didn't know. That question caught me off guard, together with my senior, Mr. Gayso, who was with us in the room. But Adam came to the rescue. And Adam said, well, actually, there's a Nubian boxer who actually had won some laurels for Kenya, but had to change his name to, let's call it, a regularly known Kenyan name, so that he could sort of fit in. And I think all of those fed finally into the committee being convinced that this was a problem in Kenya that needed to be resolved. So post the decision, what has happened? Beyond 2019, in I believe 2022 thereabout, and my brother Sipala can correct me, but he actually moderated that session. The Nubian children's case was, and the adult case, were cases selected as part of a strategy we in IHRDA were implementing then, and we're trying out. Actually, was a pilot to start some sort of soft power engagement with the state. Young Green, forgive me if you mentioned it, but we had this national dialogue, very non-confrontational, brought together the committee, IHRDA, various institutions from Kenya. And I think from there, we agreed that going forward, I think the Gender Commission was there. The National Human Rights Commission was going to more or less superintend the coordination among all the state institutions who had to ensure that the Nubians were given citizenship. I think the government team that came argued at length that Nubians had citizenship, but the process of getting the citizenship documents, they were not unique. Every other tribe in Kenya or grouping in Kenya went through the same difficulties. But I think we left that room saying that you actually had a group that needed a bit of affirmative action. So you needed to ensure that there were also processes to speed up the acquisition of the necessary citizenship documents by the Nubian community. And so, colleagues, just to tie up this first section, to say that definitely if you're going to do this for strategic litigation, yes, there are always some interesting entry points you can find to be able to at least build jurisprudence and broaden the conversation around an issue and to get structural change. So look out for those. And I would say, do not just look at the needs of the immediate victims, but look broader. Secondly, also, I think resourcing is critical. And the key lesson we learned, of course, and also with the support of the Open Society Justice Initiative, getting this done. But if you're going to go into strategic litigation, it's going to cost you quite a bit. Thankfully, today, with the e-connections and the technological world, I think the Committee of Experts has done a great job. They were one of the first institutions, I believe, after the ECOWAS court to go virtual and hold virtual hearings. So that's a plus. I think you may not need to fly to Lesotho, but you can still get your case argued, from behind your computer. Then again, also, I think the question of engagement with government, that remains a long-standing problem. You may not get the support of the government coming to the table, as we saw in this case. I mean, at some point, the attitude of the government was that this is moot because we have a new constitution. But that should tell you that beyond the initial litigation, you may have to actually continue with other angles to the issue. And then lastly, I would say that building the partnerships and strengthening the collaborations among the groups. With this case, we had very good support from the Nubian community, also from Kenyan partners, Semiride and Co have mentioned. And then also, of course, with the committee, I must commend the committee for the way they welcomed this case. This was the first case that they had on its merits. And in terms of closing remarks, with the wider implications for this and statelessness across the continent. Here in Ghana, I can tell you that with my experience with this case and where I sit in this high office, the Legal Aid Commission is working actually with some Ivorians who stand the risk of being stateless. And we're going to push through with the Ghana Refugee Board and other institutions, the Ghana Immigration Service. Just last night, I got a message from one of the members of the community fighting for a passport. And just to give some context quickly, these people don't want to go back to Cote d'Ivoire, but they also need to be given documents by Ghana presently. Those documents are not coming through. And so if both countries, national institutions, we don't work quickly, yes, they stand the risk of being stateless. So definitely, I think the decision has wide implications for us. It's a very good authority to work with, and definitely we would. So thank you for indulging me, giving you this marathon input to start with. I'm grateful.
Thank you so much, Mr. Edmund, for that insightful and brief presentation. I'm Kenyan, but out of the presentation, you seem to know more about Kenya, specifically Kibra, than me myself. Honestly speaking, I've never been to Kibra, but from your presentation, I think I need to visit there and see the legal implications of your litigation. So for that, thank you.
You should. Thank you.
So with that, first of all, it's quite also intriguing that you mentioned Mr. Sipala, who also happens to be our lecturer. So yeah, we are definitely in the right hands. We definitely need to borrow a leaf from you, from both of you, in the litigation, picking up such cases, strategic litigation, and moving this issue of statelessness from a national level now to a wider and continental issue. With that, I would like to welcome our third panelist, Mr. Shafi Ali Hussein, who is the Executive Director of the Nubian Rights Forum. So the Nubian Rights Forum is a very interesting organization. It participated in making a report to the committee regarding implementation of the case. I also happened to interact with certain documents from the forum, which were submitted to the Human Rights Council during the Universal Periodic Report regarding the statelessness issue in Kenya. So Mr. Shafi will come on board to discuss the lived experiences of Nubian children and communities, the ongoing challenges in birth registration and nationality acquisition, and assess whether state measures adequately address statelessness. So basically, he will give us a lived experience, whether the recommendations made by the committee, whether the position made by the committee were actual and they came into a reality, whether they bore fruits, or whether they are just remaining moot, there to be discussed and nothing has been done. So, Mr. Shafi, welcome. Mr. Shafi, we seem not to get you. I think, okay.
Are you getting me now?
Yeah. Well and clear.
Okay, good afternoon.
Good afternoon, sir.
Okay, my name is Shafi Ali Hussein, the Executive Director of the Nubian Rights Forum and the founder member. The Nubian Rights Forum is a community-based and civil and human rights organization in Kenya, founded in 1997. It champions the right of the marginalized Nubian community, operates within and beyond Kibra, partnering with Nubian community all across Kenya through coalition and partnership. Our mission is to empower the marginalized Nubian ethnic minority to effectively access justice. Telling members of the community about the importance of the document and having documents on time. We have a school program. This is where we give students in different schools research and later debate on them. This helps to sharpen their knowledge on citizenship and how important it is to be citizenship documented. We have a radio program We normally have session in Pamoja FM every Wednesday at 10 a.m. and every Saturday at 6 p.m. The show aims to educate community members about the importance of citizenship documents. We have the community ambassadors. This helps us identify the active members of the community and work together to disseminate and pass the information. Okay, talking about the African Committee of Experts on the Rights and Welfare of the Child, I think in April 2009, where the case was taken through by the Nubian elders, that is Nubian Council of Elders, which was being led by Mr. Yunus Ali, who is deceased now, together with the Open Society and the Institute of Human Rights and Development in Africa, brought a complaint to the African Court of Experts on the Rights Welfare of the Child. The case argued that the rights of the Nubian children in Kenya have been violated. In a case entitled Institute of Human Rights and Development of Africa and Open Society, on behalf of the children of the Nubian descent, Kenya versus the government of Kenya, number one was violation of the rights to acquire a nationality at birth. This is the discrimination Nubian children were facing and the challenges when acquiring nationality at birth, which is protected by Article 6 of the Charter. Without a clear nationality at birth, Nubian children grow up knowing they are citizens, only to realize the struggle at the age of 18. Unlawful discrimination against Nubian children. Nubian children are treated differently from other children in Kenya because of their ethnic and religious origin, for which there is no legitimate justification in violation of the prohibition of discrimination in Article 3 of the Charter. Consequential violation as a result of their historical treatment as foreigners and failure to recognize their nationality at birth, Nubian children have no rights of owning or securing any property due to lack of access to birth certificate and ID cards. Their continued uncertain citizenship status are failure to recognize their nationality at birth, which violate their rights in access to public service and registering of Huduma number. That is during the President Uhuru's time. And up to there, I think that is the reason why the same Nubian Rights Forum, which was led by I here, we took the Huduma case to court challenging the rollout of the Huduma. And we've been joined by KHRC and later on by Katiba Institute, whereby Katiba Institute have taken the data protection side, whereby we've been taking the, what do you call? We've been taking the discrimination side. So, and I think the matter is still at Court of Appeal to date. And all of you, most of you here are Kenyans, you know how Kenya court are working. So the argument made by the African court of the violation of the right to acquire the nationality at birth, the unlawful discrimination against Nubian children, constitutional violation, and recommendation as follow legislative and administrative measure to ensure Nubian children acquire nationality and proof. There's about 5 recommendations. And so far, when we took the Huduma matter to court, then after 2 terms of President Uhuru Kenyatta, President Ruto came in, and President Ruto came with Maisha number, just the same thing but different names. I again went to court, and we again took the Maisha number to court, to argue on the discrimination aspect, telling the court that all what the Nubian children have been passing through, number one, as vetting, to be addressed first before we go to Maisha number. And another part was data, the data rights. And I think all of you understood very well that by the time we went to court to take Huduma number, Kenya did not have a data law in place. It is out of that case where Kenya came with a data law, which is there up to date. So far, the recommendation by the African Committee of Human Rights has not been realized by the Nubian community or has not been fully implemented by the government of Kenya. I do remember very well last 2 years during the month of Ramadan, when some colleagues asked President Ruto about the recognition of the Nubian community. And he answered, yes, we are aware of that, and we will take measures as soon as possible. Nothing has been done. Last Ramadan, the same thing, and the president said he'll take action against and to make sure Nubian are being recognized, and nothing has happened up to now. Until when the president, I think, have been, how do I put it, challenged or requested by the Somali community. And when the president was running for the, to try to bring Somali's community out of vetting and whatever, is when we also get relief. So talking to you now, most of these things have been scrapped because you know that vetting was hectic, and then it was only a Nubian child whose birth certificate will again be taken back. Is it for verification, something of that sort, and they must pay for it. So, and also we stood firm as Nubian Rights Forum when they are telling our children to go and verify the birth certificate. Sometimes back, I took them to court. So talking now, all those things are out. They are not there. There are some small funny things, but the major problem stands with the passport. The passport vetting is there. And when you take your passport today, not like any other Kenya who may be applied today and will get next week, according to the charter, if Nubian children apply for their passport today, it might take them about 90 days or more than 90 days. So that is the problem which is still there. And I think what I like to add here, I like to add on what our first panelists have talked about, the Nubians, the coming of the Nubians in Kibra. Nubians come as soldiers under the British Army called the King African Rifles. And Adam Hussein, somebody mentioned Adam Hussein here. We're still remembering him. That man is the man who was behind all this move. And I am really, really getting hard time to push the remaining of the things without Adam Hussein. But we have Mustafa at Namati, who is also assisting. I think I cannot add anything now. I will wait for questions. Thank you very much.
Thank you very much, Mr. Shafi Ali Hussein. Your presentation for a minute has been emotional. You stating that your application takes more than 90 days. Yeah.
Exactly.
Yeah, that is quite something. But also from your presentation, you stated that the state has scrapped some of the restrictive procedures that were there initially. So
Yeah, of the ID card.
yeah, that is also quite something to note. So with that, there's definitely work to do, given that you've mentioned that the state has started the implementation, but it has not yet realized the full decision. So yeah.
Exactly.
Yeah, that is quite something. So with that, I think we can proceed with our webinar to the next presenter. So let me proceed. So our next presenter is Ms. Audrey Nafula, who is from the East Africa Child Rights Network. She'll provide a civil society perspective on Kenya's implementation of the Africa Charter on the rights and welfare of the child. Her presentation will mainly draw from their recent complementary report, which was submitted to the committee regarding the rights and welfare of the child. Noteworthy is that CLACLE also participated in the submission of the report, and we tabled also our recommendations to the committee. So her presentation will reflect on key findings from the reporting process, persistent gaps in compliance, including statelessness and nationality rights, and the role of civil society organizations in monitoring, documentation, advocacy, and engagement with regional accountability mechanisms. So with that, allow me welcome Ms. Audrey Nafula, who will take also 15 minutes to present. Thank you.
Hi, good afternoon, everyone. My name is Audrey Nafula, and I'm here on behalf of the Eastern African Child Rights Network, and it's good to have you all. So, I will give a CSO perspective from the recent submission of the CSO complementary report to the committee. I hope you can hear me. Please confirm. Okay, thank you. So the Nubian Children decisions marked a landmark ruling by the African Committee of Experts on the Rights and Welfare of Children. The committee, however, found that Kenya violated the Nubian children's right to nationality, legal identity, non-discrimination, and access to services. This decision also set a continental precedent on childhood statelessness and state obligations under the African Children's Charter. So this statelessness and lack of legal identity are regional challenges, not isolated national issues. So this cuts across the region. And the Eastern Africa faces cross-border migration, marginalized minority communities, weak civil registration systems. So regional civil society networks like the East African Child Rights Network play a very critical role in linking these national struggles to regional accountability mechanisms. They also share comparative experiences and advocacy strategies. So the regional civil society networks have contributed by monitoring implementation of the ACERWC decisions and recommendations. They have also supported shadow reporting and follow-up submissions to the African human rights bodies, and also facilitated peer learning across these countries. They act as a bridge between national CSOs, governments, national human rights institutions, regional and continental bodies, and any other actors. The ESRN convening power enables collective advocacy beyond these national silos, referencing to the most recent that was presented to the committee in December last year. From a civil society and monitoring perspective, we could see notable progress, including the increased policy recognition of statelessness and legal identity challenges. This was noted by the CSO Complementary Report, and it was also presented to the committee in December last year. They have also been able to administer reforms in civil registration and vetting procedures, greater public discourse on minority and marginalized communities, and also engagement with civil society and international actors on nationality reforms. These steps reflect some partial responsiveness to the Nubian Children's decisions. But despite this progress, there could be some significant gaps, like, for example, the lack of a comprehensive legal framework guaranteeing nationality for affected children. Also, the continued discriminationality and opaque vetting processes, unequal access to birth registration, national identity documents that have been mentioned earlier, and also the limited child-specific safeguards for statelessness or at-risk children. And lastly, weak institutional coordination and inconsistent implementation across counties in Kenya. So civil society monitoring reveals some recurrent patterns, including the administrative barriers, disproportionality affecting these minority children, the legal reforms that do not translate into practice on the ground. This means we have legal reforms on paper, but what is on paper is not on the ground. What is on paper is not manifesting in real life. So we also have children remaining invisible in systems that prioritize adult documentation. So these Nubian children, in most cases, don't participate like any other child can participate in anything that touches them in one way or another. So accountability gaps between policy commitments and lived realities is also a gap that has been seen. But the civil society organizations have used some strategic litigation and legal accompaniment. For example, CLACLE participated in the documentation of the CSO report last year, and we appreciate your participation. The evidence-based advocacy grounded in community documentation. These where organizations come in to do with things to do with research and just to collect evidence that can be used for documentation. This has also happened by engagement with parliament, relevant ministries, civil registration authorities. I remember during the development of the CSO report, we had several government officials, including the NCCS and others who are present. Also, the use of African human rights mechanisms to maintain this pressure, media and public awareness campaigns to humanize statelessness. Effective advocacy has relied on things to do on national and regional coalitions of CSOs, partnerships with NHRIs, and also engagement with the UN agencies and regional bodies, cross-border learning facilitated by networks like the Eastern African Child Rights Network. So these coalitions strengthen legitimacy, amplify voices, and sustain advocacy momentum across the region. We have, however, noted a few lessons emerging from the region, including the legal identity reforms must be child-centered and not security-driven. So anything to do with legal identity should be for the best interest of the child. It's not about the security. It shouldn't be about the security, I mean. And also the administrative discretion must be replaced with clear legal guarantees. Clarity is very, very important in administrative discretion. Also, community level engagement is essential for implementation, co-creation. It shouldn't be done for the community, but it should be done by the community. The regional mechanisms are most effective when paired with strong domestic advocacy. This is where the social behavior change and communication comes in, where you use the already existing advocacy channels to advocate for whatever you're advocating for. In this case, for the best interest of this Nubian child. And to strengthen the implementation in Kenya, we should align nationality and civil registration laws with children's rights standards. We are guided by the Children's Act 2022 and many other documents that speak about children and for children and by children. Also, to institutionalizing safeguards for children at risk or statelessness, and also strengthening collaboration between civil registries, child protection systems, and civil society organizations across the region. We should also use regional peer accountability to reinforce national obligations, possibly by keeping each other accountable of their actions and decisions about children. So I believe, or we believe, that effective implementation depends on regular state reporting to the ACERWC, civil alternative and follow-up reports, public tracking of implementation and commitments, and also transparent benchmarks and timelines. I would like to mention that civil society plays a very central and critical role in keeping decisions alive beyond adoption. So for children, accountability means things to do with timely birth registration, access to nationality documentation, inclusion in education, health, and protection systems. I remember there's a time I went to a certain school somewhere, and that school had several children living with disability, and some were using wheelchairs, but you couldn't find even a single ramp or rather a lift. So these children could even struggle to get to class, which means they were not included in that education perspective. Dignity, recognition, and belonging. Regional decisions only matter when they change every children's lives every day or day to day. So I would like to close by saying the Nubian Children's Decisions remains a powerful accountability tool, and the Kenyan's implementation shows both progress and unfinished business, like I said a few minutes ago. And the regional civil society networks like the East African Child Rights Network and other bodies are essential to monitor compliance, sustain this pressure, and also translate these regional norms into a national and local impact. Stronger accountability today lays the foundation of our statelessness free future for children in Eastern Africa. Thank you all for listening to me. So that is what I had from the East African Child Rights Network today. I hope to engage more with you. Thank you.
Thank you so much, Ms. Audrey Fuller. Thank you so much, Ms. Audrey Fuller, for that insightful presentation.
You're welcome.
So I would like to go back to Mr. Rugenge and give it a shot for the video for the professor to present his presentation. So Mr. Rugenge, the floor is yours.
people to prepare the question.
So, in the meantime, this thing of technology, it has its fair challenges of complications. So, in the meantime, I invite the audience to share with me their questions while Mr. Rugenge and his team try to share with us the video. So, anybody questions or points of clarifications or so Baba Africa.
Good afternoon, good morning for those outside Kenya and the comrades. How are you? My name is Baba Africa or Benedict Omilo from the Eastern Africa Children's Network. I want to firstly pledge my loyalty to Comrade Dr. Edmond Folle, who is my mentor in the child rights sector and a person whom I value a lot when it comes to supporting child rights across the continent and beyond. Mine is just to add on what my colleague has presented and to state that from the presentations, including from Comrade Shafi, Comrade Edmond, and also ourselves, you will find that the role of civil society cannot be gainsaid in this process of attaining justice for Nubian children in Kenya. And that also presents another challenge and reality that we have today in the advocacy, especially as civil society organizations, that these issues, and it is good that you comrades, you have taken up this matter to find how it is going, and you know that legal processes take forever. Some of the children who are involved perhaps in the initial stage are now adults. Because of this, there is a need for intergenerational support. Like as civil societies, currently we are facing financial or funding challenges. Comrades Shafi and Fole have mentioned about Semiride, have talked about the Open Society and other organizations who have supported these procedures. But in the recent past, you will find that when we are presenting the report, including highlighted these issues, you find that the committee was quite concerned about the state of implementation of its recommendations about the Nubian children. And one thing they raised is they would love to have a brief, a very a good brief about how the situation is now and whether its recommendations are being implemented. When you heard from what Comrade Shafi and Audrey presented, you find that there are still challenges. In as much as they have removed some of these barriers or bottlenecks, there are still a number of other challenges that need to be addressed. And to do this, we need collaborated efforts. For instance, one challenge that we made, that we faced during that time when we were preparing the Kenya report, as ESRN, we coordinate regional organizations. And being that we are based here in Kenya, we take that advantage, and Kenyan CSOs take that privilege. This case started before I even joined the civil society. And I can term it as an intergenerational case that needs to be understood by each generation, and especially you Gen Zs and lawyers, to continue to pick the baton. Comrade Shafi indicated that one of the comrades who was in the middle of this advocacy has already gone before us. And this means that you should get the facts right. And this will happen if we work together. We missed out on a number of organizations who were very keen on this report and basically on this communication, and basically we relied on some information, somewhat scant information, but this is the time that I was just in a meeting with the committee in a few, and I'm happy that I've met Comrade Shafi here, and the committee, the Kenya report, the state report is going to be considered in the next session, which is coming up in April in Maseru. And still, the committee accepts some briefings, and especially on this, if Comrade Shafi, we can liaise so that, and Comrade Edmond, we can liaise so that you can do a brief about the state of it, because the state has also, the Kenya government submitted and mentioned something about the implementation of that, but we know that it is sluggish. There are things which are supposed to be addressed specifically, and this can only come from you, Comrade Shafi, and people who are at the middle of this. So I just call for collaboration, and especially at this time when the civil societies are facing teething funding issues. Thank you for this, and thank you, Comrade Ugenge and Comrade Wamba, for the opportunity.
Once again, thank you. For clarity, that was Benedict Omilo, the Executive Director for the South African Child Rights Network. I see Rugenge is up with this video, so I think the video can be played, then we'll proceed with the questions. Okay, so video, please.
I recognize questions that can take us in. I recognize questions that
Okay, so maybe I'll go first. So my question, okay, let me say it's not more of a question to Mr. Edmund. Mr. Edmund currently is the executive director for the Legal Aid Commission in Ghana. He's moved to the government side. So, Mr. Edmund, you also mentioned briefly of how your country is also having the issues, facing challenges of statelessness. And now from the government side, given that from the presentation of Mr. Shafi, which he said that as much as Kenya has tried to realize the fruits of the Nubian decision, it has tried to implement some of the decisions. Not the entire of the decision has been implemented because he stated precisely that they still face challenges, like they still face a 90-day application window. That's a very long time for them to gain their identity cards and their birth registration. So from the government side, maybe from a comparative analysis, how do you face such things from the government side now, having worked with the Legal Aid Commission? How does Ghana treat such cases, or how do you face such scenarios?
Right. Thank you very much. I think it's not a perfect system, but perhaps one I could say edge that for us in Ghana we may have over Kenya at the moment is the interagency collaboration. So persons who, we do have quite a few people who in Ghana have been seeking Ghanaian citizenship. A classic case is the case of the Fulani. So anybody who is familiar with West Africa would know that the Fulani group stretch from northern Nigeria right all the way through to Senegal. For those who've lived on that part of town, the Fula people you mostly find in Senegal, Guinea, the Gambia, some parts of Mali, are related to the Fulani in a way. Now, the Fulanis have traditionally been nomadic, mostly moving with their cattle. But we've also had sedentary Fulani. And so historically, when you talk of Fulani, for instance, in Ghana, most people would then think of the nomadic. And so the sedentary, who have always been part of Ghana, face challenges sometimes with getting documents. So at the institutional level, we've seen some good collaboration between my place, the Legal Aid Commission. We've and in the specific case of the Ivorians also, we work with their embassy to facilitate they getting passports from their embassy here, at least cases that are on my desk at the moment. So something can be said for the interagency collaboration, which at least is helping. I wish that with the constitutional review process, we would be able to settle once and for all some of the thorny ones, like the situation of the Fulani and have that written into the Constitution so that there is no legal ambiguity as to their status. Great.
Thank you. Thank you for that short and brief answer. I see Scam Joe's hand up. So, just Scam.
Thank you, Joshua. I think I'm audible. From Mr. Shafi's presentation, I noticed that he acknowledged that there are steps Kenya has taken in implementing this decision by the committee. And I feel like implementation should not only be assessed through legal reforms and policy statements, but also in administrative practice. And in particular, my experience, I think it provides an empirical evidence on the gaps that we have in implementation. Last year, I worked in an organization, Capital Registrars in Nairobi, and I happened to observe that a number of adults, actually 2 of them were Nubians, were unable to access things like basic documentation in terms of passports because of essentially lacking identification documents showing that they are Kenyans. And you find that some of them were required to produce affidavits, and that affidavits explaining the absence of such documents. And in the long run, you find that they incur additional financial costs in obtaining those affidavits. And secondly, they'll also endure the like a significantly longer processing time than a processing period than ordinary people, or like other persons who are privileged to have the identity cards, in addition to that 90-day period that Mr. Shafi had noticed earlier. So my point is that, considering that this comes from a point of discrimination, reading from the committee's decision, it speaks volumes to the urgency that we need in implementing this decision by the committee. And I think we are in agreement that this decision should be implemented as fast as possible to ensure that the systemic barriers and the systemic inequities that are meted on these people because of the lack of or the absence of identification documents is reduced. Yeah, thank you.
Okay, thank you so much, George Skem. From my analysis of your presentation, I think that was not a question, that was a contribution, but much of it, it's much welcomed. So yeah, anybody, the contribution are also welcome. So Ruginga and Chico.
Can you hear me? Yeah, I have a question. My question is directed, I'm Rugengi Wanchiko. I'm also a clinician at the Center for Legal Aid and Clinical Legal Education. And my question is directed to Mr. Edmond, as well as the civil society representative here, like Audrey and Baba Africa, is when it comes to statelessness across the region, because the Eastern Africa Child Rights Network cover not only the situation in Kenya, but across the region. And also, I would like to know whether we have such problems also in Ghana, if Mr. Edmond can also tell us, because what you have seen is this right is an intergenerational right, which means if you don't have nationality today as a child, it means even your children, your grandchildren, and great-grandchildren also will be affected in such a manner. And also, what are some of the way in which they deal with the same situation across different places in Africa? Yeah, thank you.
Right. Thank you. Thank you very much. And I think your question is very apt. We do have, and as lawyers, it's quite interesting, the framing of the early constitutions and subsequent ones that we have had. So in Ghana, for instance, from the the 1957 Independence Constitution, well, didn't say much. The 1960 First Republican Constitution, you have those provisions that would say things like any person whose father or grandfather was a citizen of the colony, and for those of us who were coming from the British, either the colony or the protectorate, and those two mean very different things. You had some of those provisions being carried right down through. So for us in Ghana, it is possible to actually find more than 16 potential situations of statelessness, even for persons who call themselves Ghanaians to date. And that is why, in our case, the Constitutional Review Commission has also looked at the provisions on citizenship in our Constitution and made some recommendations for us to resolve this once and for all. So we do have, even for persons on the territory of Ghana who claim to be Ghanaians, but who potentially may not be Ghanaians, as well as persons, as I indicated, like the Fulani, who have always been Ghanaians, but sometimes, due to ignorance, some officials in the passport office, in the National Identification Authority, tend to say that no, but Fulanis are sedentary. So we do have here, but I think once we have this constitutional review process underway, it should resolve to a large extent the constitutional challenges as well as the statutory challenges that would flow from that, and then we are able to deal with these issues in a more structured manner. Thank you.
African origin.
If I had
Hello?
to get right.
Okay. Yes, just like Comrade Foley has mentioned, the problem of statelessness, and as it was clear in the presentation, the problem of statelessness in the region doesn't only affect Kenya. Just that the Kenyan case was now taken forth, and I think there was a lot of attention.
Mr. Benedict, you're having trouble hearing you. I don't know, it's on my end.
By various stakeholders, as you have heard. But again, in the region, there are those as ESRN or Joshua, are you able to hear me?
Yeah, we can hear you, but we are having some difficulties hearing you. It's not that consistent. You're breaking.
Okay, I think it is a net challenge, but as I saying that
Yeah. Right now, I completely can't hear you.
the country is stable. It has experienced a lot of. I've found out that it is also as a result of. Okay, I think I'll share my response, but if because it seems there is a challenge with the connectivity. Hello.
Okay. Right now, I can hear you, so you can proceed.
Okay, thank you. As I was mentioning, and let me be brief now, that other countries have had some challenges, and just that this problem has not been brought forth or brought to the attention by civil society organizations or concerned parties. Countries like Burundi, Ethiopia, when you look around, Rwanda also have some cases of some of people suffering from statelessness, and just perhaps it might not be a situation as opposed to what some countries are, or just as I said, perhaps it has not been brought forth by stakeholders, and this is something that also has to be considered. And I'll call upon organizations like IHRDA. I know Comrade Edmond is no longer there and is now speaking on behalf of the government. Perhaps as a result, you cannot travel because you cannot be given or you are not recognized by the laws of that country as a citizen. So this is something that I think has to be taken up not only by the African Committee of Experts, but also by the African Commission on Human and People's Rights, because you find that, as mentioned earlier, that some of these children who were in the Nubian case, they are now adults. And now it should not just only focus, it is a human rights issue generally. And as you know, children's rights are human rights issue. So it should be taken by a multi-agency approach so that, you know, the issues also get addressed at regional level. And it is something that I believe with the expertise of comrades here and civil society organizations, Pan-African institutions, we can start looking towards that direction. Thank you.
Thank you so much for that answer. Anybody with a further question? Okay, I see Rugenge's team is up with the video, so we may give it a try for the last chance.
I recognize all of you in your respective capacities, and I request that I stand on the existing protocol. It's always an honor to speak to bright minds in the room. I recognize all of you in your respective capacities, and I request that I stand on the existing protocol. It's always an honor to speak to bright minds in the room, to join conversations that bring together government, national institutions, civil society, academia, and community leadership around one shared priority: improving the lived experience of children through practical implementation with regard to their rights. At the outset, allow me place a caveat. I'm speaking in an academic voice in my capacity as an academic, reflecting on the practical question of how regional child rights decisions translate into implementation. I hasten to add that implementation of decisions is an area of my ongoing academic research, and it's from that scholarly interest that my engagement with today's theme is principally drawn. Nothing that I say should be taken as a formal statement or pronouncement on behalf of the African Committee of Experts on the Rights and Welfare of the Child. I do, however, have the privilege of serving as a member of the committee, as a chairperson of the Working Group on Implementation of Decisions, as well as Special Rapporteur on Children Affected by Armed Conflict. I mention these roles only to situate my interest in the aspect of implementation as a shared continental priority, and not to elevate my remarks beyond an academic reflection. With that in context, please let me commend the Center for Litigation, Advocacy and Legal Education for convening a conversation that is intentionally focused on a question that is often the most difficult in our human rights ecosystem: implementation. Decisions and concluding observations have the highest value when they assist states, national institutions, and communities to identify practical aspects in terms of steps, reforms for prioritization, and measuring progress over time. Ladies and gentlemen, today's focus, the committee's decision on children of Nubian descent in Kenya, is best approached from that constructive spirit. The decision on its own provides a set of clear reference points against which progress can be understood. In brief, it speaks to ensuring that the Nubian children who would otherwise be stateless can acquire nationality and proof thereof at birth, and that priority attention is given to existing cases, that birth registration is implemented without discrimination and immediately after birth, and that there is a time-bound approach to the realization of education and health rights, ideally developed in consultation with affected communities. My intervention stems from the argument that implementation of this specific decision should be assessed and advanced through verifiable Nubian-specific outcomes rather than through general references to reforms. To that end, nationality, proof of nationality, and immediate non-discriminatory birth registration are realized in practice. In that light, the communication addressed the prolonged difficulties faced by children of Nubian descent in accessing effective legal identity, particularly birth registration and recognition of nationality, with consequential exclusion from the equal enjoyment of related rights, leading to the committee to finding Kenya in violation of the Africa Children's Charter. Some of the articles were Article 6, sub or clauses 2 to 4 on name, birth registration and nationality, and Article 3 on aspects of non-discrimination, among others. The committee recommended that Kenya takes legislative, administrative, and other measures to ensure Nubian children who would otherwise be stateless acquire Kenyan nationality and proof of nationality at birth, adopt priority measures so that the existing children whose nationality is not recognized are systematically afforded the benefit of those measures, to implement birth registration without discrimination and ensure that Nubian children are registered immediately after birth. Most importantly, to adopt short, medium, and long-term measures to realize the rights to education and health, preferably in consultation with affected communities alongside timely reporting on implementation. But ladies and gentlemen, the critical question now becomes, how do we deal with legislative, administrative, and other measures in absence of potent identifiable outcomes? To that end, from an implementation perspective, it's important to note that we should distinguish between enabling measures and experienced outcomes. Enabling measures include the legal and administrative frameworks, the institutional reforms, the registration systems that lead to policy direction. I believe these are important building blocks. Outcomes, however, are measured in the lived reality of the children and their families. That is to say, whether the processes are accessible, whether documentation is obtainable within reasonable time frames, whether decisions are consistent and non-discriminatory, whether remedies reach the children to the end that they have the ability to say that they have got what was intended. I must say that Kenya's periodic reporting has over time referred to important enabling measures: constitutional protection of children's rights, legislative provisions on nationality, and population registration systems. From an academic standpoint, this can be seen as part of the broader architecture within which implementation can be advanced. At the same time, on the other spectrum, the committee's engagement with Kenya through the reporting processes has also underscored areas where further work would be beneficial. In the committee's concluding observations on Kenya's first periodic report, it indicated that more needed to be done to give effect to the Nubian decision, particularly in areas with regard to access to birth certificates and national identity. In terms of documentation, more recently, The committee's internal status reporting on implementation reflects continued engagement, such as consultations, and highlights an area that many states face in practice: the need to demonstrate with clarity and evidence how general reforms translate into the need to have that specific beneficial group identified in the decision. The status report notes that while procedure changes were referenced, the discussions would be strengthened by Nubian-specific evidence of benefit, a clearer plan of action that responds to Nubian-specific challenges, and further clarity on community awareness and accessibility of procedures. I call this the place of putting that specific child at the center of the interventions and ensuring that these interventions speak to that child from a holistic perspective. Why do I raise these points? It's an invitation to Kenya to a shared method of implementation, one that assists the state to demonstrate progress credibly, assist national institutions and partners to support the delivery, and assist communities to experience tangible change. So you'll allow me propose 3 ways in which these constructive steps can support this shared method. 1, a simple evidence picture of outcomes, where it goes beyond reporting to precision on clarity, where data and practical indicators show how the Nubian children are progressing through the documentation pathway, in terms of birth registration, in terms of confirmation of nationality where relevant, and access documentation that enables full enjoyment of rights. Where there are delays or refusals, it's important that we understand where and why they occur, such that solutions are targeted. It remains a continuum. Secondly, a time-bound implementation plan that is responsive to the specific context. The decision itself anticipated and continues to anticipate short, medium, and long-term measures, ideally developed within the participation of the affected communities, the Nubian communities. A plan of this nature helps government to coordinate across institutions, allocate responsibilities, and set realistic timelines. It allows partners such as the Kenya National Commission on Human Rights, civil society, development partners to align support to clearly identified priorities. And thirdly, strengthening accessibility and public understanding of procedures. Where administrative processes evolve, because they always do, it's beneficial to ensure that the communities are informed in practical terms what is required, where to apply, the expected timelines, the review avenues if an application is delayed or refused, and the measures taken to ensure non-discrimination. This report, this internal report from the committee, suggests that this is an area where further clarity would be valuable. This is where the Center for Litigation, Advocacy and Legal Education come in. Law clinics, universities, the Kenya National Commission on Human Rights, civil society, to play a helpful role in a way that supports the state. Clinics and partners can assist with structured documentation of lived barriers, community legal empowerments, referral pathways, and periodic implementation snapshots that are evidence-based and solution-oriented. Allow me add one brief point from my other life as a special rapporteur on children affected by armed conflict, but in a careful way that is consistent with today's theme. Legal identity and documentation are not simply administrative concerns. They often function as protection tools, particularly for children in contexts of vulnerability. When documentation pathways are clear and non-discriminatory, children's access to education, health, and protection is strengthened. This aligns with the Nubian decisions linkage between nationality on the one hand, documentation on the other, and the realization of socioeconomic rights. It should be recalled that from a normative perspective, the committee, using engagement from the Charter, does not distinguish between civil and political and socioeconomic rights, being a place on the uptake for the Nubian decision to engage. Let me conclude with a constructive proposition that we treat implementation as a shared governance exercise, not only for government and national institutions, but for civil society and communities, supported by a small set of practical indicators and a time-bound plan. In doing so, Kenya is best placed to demonstrate progress confidently, and the committee's engagement is best placed to remain collaborative predictable, and supportive of national delivery. I believe with these few engagements that as we have the conversations this afternoon, this evening, we shall be able to reach with concrete steps on how to ensure that implementation is not only theoretical, but is practical. With those few remarks, I thank you for listening to me. Thank you very much.
What a presentation. What a presentation from Professor. Too bad that he isn't here in person. Nonetheless, we appreciate the time and effort he took in recording the video. So I'd say from the presentation, I share in his third proposal of getting awareness and strengthening the communities in the awareness, because essentially that's what CLACLE is about. As a legal, a student-led clinic, we are about creating awareness to the community, creating awareness about such decisions, and getting awareness about the community and their rights, so they can know such decisions were made. And in this, when communities are equipped with the awareness, they're equipped with the information about their rights and everything, I think that can be the first step of them claiming their rights, of them going to these state offices, the government offices, and asking the government offices, we're entitled to this. I'm entitled to be registered in this way and this way. Why the 90 days? Why me? Am I being subjected to 90 days while other children of maybe a different origin are not being subjected to the same? So with that, I don't want to close this opportunity to anyone. Anyone with a question or a point of clarification? So allow me to welcome Mr. Rugenge Wanchiko, the chairman for CLACLE, to issue his vote of thanks, and thereafter welcome Mr. Ikisa, who will close the session with a closing prayer. Thank you.
Thank you very much. I'm Rugenge Wanchiko, and as I've been introduced, I currently serve as the chairperson of the Center for Legal Aid and Clinical Legal Education, the CLACLE Clinic. And on behalf of CLACLE and our partner, the Eastern African Child Rights Network, I extend our sincere gratitude to all the people who have joined and support this webinar, particularly our school administration, Ms. Juliet Gachanja, our HOD, Mr. Kelly Malenia, and all the students and the CLACLE team. Also, apart from that, we are deeply grateful to our esteemed panelists. Young Green Peter Muge, who is just seated next to me. We also thank you, Mr. Edmund, because he has taken time to join us all the way from Ghana. We thank Mr. Fachi, the executive director of the Nubian Rights Forum. We also thank Audrey for the insightful presentation from the civil society organization. We also extend a special thanks to our moderator, Joshua Fwamba, who has taken time to guide our discussion and make sure it's focused on this specific webinar. And also, apart from that, we also thank the participants and all the audience for making time for this important opportunity. We hope this will just be a continued commitment to make sure implementation is just a shared responsibility, as has been said in the video by Professor Roberts. And even though he was not there as well, we thank him for making time to do the video which has been played, and for making time also to support us. That being said, I think we are hoping to continue collaborating and having you engage in our webinars and other activities. And thank you very much for making time to be there today. And without further ado, I invite Ikisa to do the closing prayer. Thank you very much.
Okay, thank you so much, Rugenge. Yeah, let's pray. Father, in Jesus' name, we thank you this afternoon. We thank you because of your love. We thank you because of the webinar that you enable us to have this afternoon. We thank you because of everything we've discussed with regards to the Nubian children, oh God. We pray that
afterwards and moving forward, we will ensure that the children get their rights, oh God. And I pray as well for the department